The federal DOJ under Pam Bondi continues to progress in their effort to support the Second Amendment. This isn't another amicus brief in an existing lawsuit. This is the DOJ filing its own lawsuit against the LA County Sheriff's Department for their awful CCW wait times. Let's talk about it. Hey everybody, welcome back to the channel today. Another good, positive, directional push for the Second Amendment in California as the federal Department of Justice steps in. We've seen them get more and more involved with lawsuits throughout the country, but now they have done another unprecedented thing by filing their own. To walk us through that today, we have brought back on CRPA's volunteer president. That is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to the videos. It really helps with the algorithms to push this out as far and wide as possible. These are good things. We want everybody to be able to celebrate in them, especially when they have such a good promise at the end of the tunnel to produce good results. So if you can, like, share, subscribe, throw some comments down there in the comment section. It really helps. So let's just dive on into this, guys. From the Department of Justice Office of Public Affairs, Jacob, if you could pull this up for me, it reads like this. The Civil Rights Division today filed a lawsuit against the Los Angeles County Sheriff's Department due to their pattern or practice of infringing the Second Amendment rights of law-abiding citizens seeking concealed carry weapons permits. This lawsuit is the first affirmative lawsuit in support of gun owners filed by the Department of Justice. On March 27, 2025, the division initiated the first of its kind Second Amendment investigation due to numerous complaints of unreasonable delays in CCW permitting decisions by the Los Angeles County Sheriff's Department. After analysis of the data and documents spanning over 8,000 CCW permit applications, the division today filed suit seeking relief on behalf of law-abiding applicants. The Second Amendment protects the fundamental constitutional right of law-abiding citizens to bear arms, said Attorney General Pam Bondi. Los Angeles County may not like that right, but the Constitution does not allow them to be infringed. This Department of Justice will continue to fight for the Second Amendment. Shortly after Assistant Attorney General Dillon was sworn in to lead the Civil Rights Division, numerous complaints received by the division revealed inexplicable delays well beyond California's statutory requirements and in violation of the U.S. Supreme Court's interpretation of the Second Amendment rights of law-abiding citizens. Almost 2 months after receiving notice of the division's investigation, Los Angeles County Sheriff's Department provided data and documents that revealed only 2 approvals from over 8,000 applications, and that the Sheriff's Department set out interviews to approve licensees as far as 2 years after receiving completed applications. The lawsuit is filed within the Federal District Court of California. The investigation was conducted by Attorney General at the Civil Rights Division and Assistant U.S. Attorneys within the Central District of California's U.S. Attorney's offices. So, Chuck, good news, and I know that all the way back in March, you know, the DOJ put out this thing saying, "Hey, we're doing this investigation." CRPA was to a certain degree involved in that, sending them information that we had, and then here we see that they are basically attacking the LA County Sheriff's Department for the same things. It looks like that we went after them for. You got the long wait times, and you got the high fees. We were successful in that case, right? Although we did see parts of the opinion end up being specific to the applicants themselves. What exactly does it mean for the Department of Justice to now have a suit like this, and what are the results that you expect to get out of it?
Well, first of all, remember, CRPA's lawsuit is still going on, and we're joined with Second Amendment Foundation and Gun Owners of America and some individual plaintiffs in that lawsuit. That is still going on. And we had gotten a few good rulings so far. Most notably, out-of-state residents can apply for a CCW in California now, but there's still a ways to go. There's still a ways to go. We did get that great ruling, but we're still working with them to cut their wait times down and speed up their application process. You know, the problem with the system is, a lot of these jurisdictions can play games. They can game the system. They won't accept your application because they don't want to start the 120-day clock running. They won't accept the application. You have to wait in line to just submit the application because they don't want to start that clock. Or they require you to wait until your background check is approved before you can do the training or some of the other requirements, which for example, in Riverside, they let you do that stuff while your background check is pending. Now, if you get turned down in your background check because you're a prohibited person, you will have wasted that money, but that's up to the applicant. If they think they're going to clear, and most people will, then they can start the process, do the other things, the other parts of the process while the background check is pending. It cuts months and months off of the processing time. But LA Sheriff has, for decades, LA Sheriff and LAPD have, and San Francisco, although they're now towing the line much more according to the Bruin decision. But LA Sheriff and LAPD have been notorious for being anti-issuing CCWs. And so it's about time that the federal government called them on the carpet to answer for their bureaucratic resistance to the Bruin decision.
Yeah, we continue to see unprecedented things with the Department of Justice. We saw them file amicus briefs in a couple other cases, and now they take it a step further and file their own lawsuit. Are we kind of considering this a promise delivered from a Pam Bondi DOJ all the way back in March when they set out to start the investigations? And also, why do you see them honing in on LA when they have the entire country to look at?
Well, LA Sheriff is one of the worst, but also we turned over a lot of information to them from what we found in our lawsuit. So we've been working cooperatively with them for a while. They announced their pattern and practice investigation, and part of the reason that investigation was begun was because some of the things we uncovered, the plaintiffs uncovered in the lawsuit that we filed against LA Sheriff. So, it comes down to LA Sheriff doesn't want to put the resources in. They say they can't process these applications any faster, but that's baloney. There are private companies that will process the application for them. Former police officers that now have started businesses in speed lighting, in speeding up the application process. Or they can simply put retired deputies. That's what Riverside does. They put retired deputies on to process applications. There's no excuse for this other than they have other priorities. And, maybe you shouldn't give as much money to housing illegal immigrants or other benefits to folks that aren't constitutionally entitled to them, and pay attention to satisfying your constitutional obligations to give people the permits that they have a constitutional right to get.
Right, and it does kind of work against itself, right? We have the constitutional right to carry a firearm. If you're going to set up a process that we have to go through to get it, you darn well better meet your end of the bargain within that process. So that does tend to
burdensome application system. We didn't create character references and psych reviews and 18 hours of training and all the other things that all the other hoops you have to jump through to get a CCW permit. The state did that. And part of and only a 2-year license. So you've got to reapply every 2 years, take more training every 2 years. It's ridiculous. And it's really, the state is just as culpable here, the state legislature, for setting up these obstacles. We had a bill, CRPA had a bill, still has a bill, that would expand the license term from 2 years to 4 years. So at least that would cut the costs in half and cut the burden on the administrative agencies in half, because they'd only have to do it every 4 years instead of every 2. But they're stalling that bill in Sacramento because it's now passive aggressive hostility. It's now, they're not saying you can't have a license. They're just throwing up all these red tape and costs so that people will give up, and then also, of course, creating sensitive places where your CCW is invalid, even though there's never been a problem with CCW holders having their firearm in those places for 100 years, because that's how long the system was in place. So it's ridiculous, and we're just really thankful that the United States government is bringing the full weight of the Department of Justice onto LA Sheriff to make them toe the line.
Yeah, definitely something to look forward to. I am kind of curious, though, as far as the lawsuit is concerned, is this the only action that DOJ can take? And if it isn't, is it the most efficient? Why is it that we see them attacking this problem with more litigation? Is there anything else that they could do?
Well, they could. I don't know what kind of federal funding the LA Sheriff gets, but they could pull that. But other than that, the what the LA what the U.S. Department of Justice can get that we couldn't really get is a consent decree. In other words, the LA County Sheriff is going to have to agree to do certain things, and they're going to be monitored. They're going to have to send reports to the United States Department of Justice about what kind of progress they're making. Now, we had a similar setup with our a lawsuit that we're trying to resolve with LA County Sheriff and force them to shorten those applications times. But the DOJ, they can fine them. They can, as part of this lawsuit, they can do all kinds of things that we don't have the power to do. And also, the judge in this case is very busy, and so it's hard for us to get relief from her quickly. The United States government will be able to get it more quickly than we can. So it's a great move. What's probably going to happen is these cases will be either coordinated or consolidated into one case in the Central District of California. And we'll be working together with the United States government to make sure the LA Sheriff does this. By the way, when I was in Chicago last week for the oral arguments in the Illinois law banning semi-autos, I met Harmeet Dillon, the head of the Civil Rights Division. She's a great lady. She had a law firm out here in California before she was appointed. And I told her we've talked about a number of things that are going on in California. So I don't think this is going to be the last thing we see from that Civil Rights Division of the United States Department of Justice.
Well, an expedited time frame certainly sounds good when you're talking about litigation. Also, another good thing to look forward to, some things that DOJ can seek that we necessarily can't. If you had to, kind of take out some of the larger points of this lawsuit, what would they be?
Just the number of applications versus the number of granted licenses. They said there was 8,000 applications and only 2 licenses granted, and that's from the information that they got directly from the sheriff. Now, I thought there was more licenses than that, so that's something I'm going to double check today. More licenses issued, but it wouldn't surprise me. I mean, they're setting interviews out, a year after you submit your application, and they're trying to claim that there's a 120-day clock in state law. You have to process the application within 120 days. They're trying to claim that clock doesn't start until they do the interview. Well, no, that's not how it works. The second that application is submitted, that clock starts. So this is what something LAPD is doing too, playing games with when the application is accepted and when that clock starts so that they don't get in continuous violation of state law.
Well, I got to tell you, the more and more people that I speak to who have applied for CCWs in the county of Los Angeles, the more likely that number seems to be true. It seems like there has been difficulty in every corner of the application process for those who I personally have talked to. But perhaps, Chuck, another video, we're going to have to get you back and really dive into the text of the complaint. A lot to look forward to here. Any final thoughts on momentum of this, how quick you think it's going to move?
One of the things that we're talking to the Department of Justice about is the state regulatory scheme as a whole, not just one jurisdiction delaying applications and delaying issuing of permits, but the whole way this system is set up. Like, that's why I said earlier, the state is part of the problem too. They set up a 2-year permit, short permit term. They set up psych evaluations, which are not mandatory. You don't need to do that every time. They set up 18 hours of training, and then they said that the jurisdictions and all the other requirements. Then they said the jurisdictions can recover their actual costs. Well, the jurisdictions then have an incentive to be inefficient so that it costs more if they want to discourage people from applying. That's why we have a lawsuit against Santa Clara right now, because they're charging $2,000 all in to get a CCW. So we're looking at CRPA, SAF, GOA. We are all looking at challenging the state regulatory scheme as a whole and forcing some revisions. You don't need to have a permit term at all. There's something called the Certificate of Eligibility in California, a COE, and if you get a COE, if you have one issued to you, it says you are eligible to possess firearms. You're not prohibited. But if something happens, you get a felony conviction or something like that that puts you in a prohibited class, the COE is revoked. So if you have a CCW and a COE and you get in trouble and your COE is revoked, your CCW can be revoked. Otherwise, why have a term on it at all? You know what I mean? So the system is just still set up to frustrate applicants. Consider what this would be like if the how many million people are there in LA County? You know, usually about 5% of a population applies for a CCW. And then the reality is a lot of them don't actually carry it on their person because it becomes, it's literally a pain in the bottom to carry a firearm around all the time. But the bad guys don't know who has them. And so, you know, no, if 5% of the population might have a firearm, bad guys aren't going to take a risk that 1 out of 20 people that they try to rob might be able to shoot back. You know, nobody goes duck hunting if 5% of the ducks shoot back. So it's you know, it's just very encouraging because the more CCWs are out there, the less people are going to be afraid of firearms. And that terrifies people like Gavin Newsom. They want people to be afraid of firearms. They want to claim that the state is making them safer, and nothing could be further from the truth than that. These gun laws don't make anyone any safer. But that's not the narrative they want to push. Well, this may force that narrative to change as people become accustomed to other people having a firearm in public.
Indeed. So a lot to look forward to there, Chuck. I want to thank you very much for coming on and sharing with us, and look forward to the next one.
Always a pleasure. Hey, folks, if you have an issue with CCWs in LA County, send an email to helpdesk at michellellawyers.com, and we'll get that information to the United States Department of Justice, because they're looking for basically witnesses, people who can give testimonials about the problems that they've run into. And
Absolutely.
please continue to support CRPA as we continue to push the CCW Reckoning Project through in every jurisdiction in California. LA Sheriff may be one of the worst, but it's not the only one.
Absolutely. Thank you once again, Chuck. I do always appreciate you coming on. It is very helpful, and look forward to the next one with you.
Look forward to it, Kevin. Thank you.
Absolutely. And guys, like Chuck said, if you want to help, if you want to contribute directly to efforts like this, please be sure to like, share, and subscribe to the videos. That also really helps push this movement forward. We're trying to get this info out to as many people as we possibly can. Thanks again, guys. We'll see you on the next one.